Welcome to this installment of the More Than Human series. We're doing this time a bit a different format. We're doing video interviews with some of the people that in the last few years actually we have worked with in terms of as moderators or as co-curators who themselves have very interesting research or work that they're doing that we thought would be great to highlight via this format. For today, we have invited Minea Tănăsescu. Do I pronounce that right?
Almost.
Okay. You do it right.
Okay, I'll do it. I'm Mihnea Tănăsescu.
Mihnea Tănăsescu.
Yes.
Welcome.
Tell
me, who are you? What do you do?
That's a good question. So I'm a research fellow at the VUB, the Free University of Brussels, and I work in environmental humanities, political ecology, and for people that are not into academia, that simply means that I'm really interested in how humans relate to their environment and the more than human creatures around us.
Yeah.
And that sort of broad topic has led me to work on a couple different things.
Okay.
I'm really interested in nature conservation and how to restore nature that's been degraded. That's been one area of study. And the other one is what we're talking about today, which is the idea and practice of giving rights to nature.
Yeah, yeah. But before we get into that,
yes.
Like I said earlier, you have been part of the More Than Human series, More Than Human Encounters series. You've been part of that. And I thought maybe you could share with the audience what exactly you did with Crosstalk.
Absolutely. So that was last year, during the last series of More Than Human Encounters. And I co-curated together with a team from Crosstalks and Kai Studios a particular evening on the idea of personhood. And we had two wonderful guests. It was Marisol de la Cadena, an anthropologist from UC Davis, and Isabel Stengers, philosopher, Belgian philosopher. And we talked about, through the anthropological work of Marisol, about this idea of personhood and what it may or may not apply to, and how you may also sort of destabilize the idea of the human by looking at other creatures as potentially persons.
Yeah. Well,
I had a fantastic time.
Yes.
I had a good time.
It's all on the website, so check it out again. But about you, so I don't know if you got an opportunity back then to kind of talk about your own work, as it is kind of tied into this notion of personhood and the ways in which that can be destabilized, the idea of human or the moral value of humans versus everybody else. But before we get into what you do, I was thinking we could just start off with a few definitions, right, that can help us sort of understand what the terms that we're going to be using later on a lot, right? So I wrote them down from your book, the Understanding the Rights of Nature, which is a really interesting book. You published last year, like early last.
It feels like I published it last year because I finished, you know how it is, you finish it a year ahead of time. But it came out this January.
This January? Yeah. Get it.
2022.
For the first concept I wanted to ask you a definition for is the rights of nature. You've already mentioned it a few times.
Well, if I come up with a definition of that, I think there would be an achievement. Okay, so the rights of nature is exactly what it sounds. It's the idea first, and then increasingly the practice of using rights, which is a legal mechanism, for either landscapes or nature as such. So this is different from animal rights. It doesn't deal directly with creatures, but it deals more with what we call nature as such. So ecological processes, different areas. A lot of it has been applied to rivers.
Yeah.
And very briefly, I think what it means then to have a right is to have a claim that someone is supposed to treat you in a certain kind of way. Yeah. That's what it is to have a right. So basically at its base, the rights of nature are the idea that nature should have legally enforceable claims.
Yeah. And for the listener who might be like, what do you mean rights? Like what kind of rights can nature have? In your book you talk about things like right to life for nature, right to not be polluted and so on. But there's also a certain dimension to it of people living there that have a right to nature as well, right?
Yes.
How is that tied in with rights of nature, or is that strictly speaking not rights of nature? Am I getting too technical now?
No, not at all, not at all. So there is a difference between rights of and rights to nature. And the rights to nature are already pretty well established as human rights. So the right to a healthy environment, for instance, is a right to nature, right? The right to access water, for instance, is a right to nature, to a certain service that nature provides, right? The rights of nature are supposed to be independent of that. And there's a big discussion whether, you know, those can come into conflict or not. And I explore that in the book in ways that, you know, in practice, you always have to weigh those against each other. Because it may be that your right to nature infringes on a right of nature. And to give, you know, an example and come back to the beginning of your question, what kinds of rights nature can have. In each particular example so far, they're slightly different. But for instance, one of them is the right to its own ecological processes. Right? So
undisturbed.
Right.
Right. Okay.
Yes, and you know, that's also a contentious thing. Like, you know, where do you look at a particular river to say this is when it's undisturbed? You see? But leaving that aside, it means, for instance, if you divert a river for a hydroelectric project, then you are interrupting certain ecological processes that have defined it before. And in that sense, if that river has a right to its own processes and its own evolutionary path, as it were, then you could potentially be infringing on that right.
Okay. Now, that's that. Rights of nature, rights to nature, but then...
Short definition.
Short definitions. Yeah, very short. Very good. Then there is legal standing. And I'm kind of always, I think it's interesting for everyone to for people listening perhaps, to understand how that is tied into the notion of a rights of nature. And you do that really well in your book. This book is amazing. You should read it.
Thank you.
Give us the cliff notes.
Okay, so legal standing, that is a really important one. And it's a really simple concept, actually. So legal standing, you either have it or you don't. Okay? And what it means to have it is that you are recognized as an appropriate party to bring a claim in court. So if, so this whole, the relation between legal standing and the rights of nature really started in the United States, where you only have legal standing, you can only bring a claim if you are directly harmed by what you're claiming, right? So if your particular rights are infringed upon, you have legal standing to, you know, sue to defend your rights. Or if your property is affected, for instance. So if I discharge a pollutant on your property, then that directly harms you, and then therefore you can sue me, and you have legal standing to do so. But if you sue on behalf of nature, you don't have standing, because you are not necessarily the harmed party, right? So the issue of standing is really important because it decides whether you can even talk legally about bringing a claim on behalf of a nature that you're not connected to as a property owner, right?
But so, can legal standing be a right of nature, or is it more specific, like a sort of a formal legal mechanism to bring claims of nature to the court?
It's just a requirement for your claim to count, basically. Giving rights to nature establishes standing, right? So to give an example, in the Ecuadorian constitution of 2008, which was the first constitution in the world to include rights of nature, it says explicitly that anyone has standing to defend those rights. So basically that removes any kind of barrier, right, to who can claim that the rights of nature have been infringed.
We'll talk about some of the risks involved with that later on. But okay, so the next concept that is, I think, maybe familiar to our audience, but might be good to just sort of lay down again, which is the concepts of anthropocentrism and ecocentrism.
Yeah.
Do you want to like break that down for us? Because I think it might be helpful later.
I can try.
Just very easy terms and definitions.
They're a mouthful, right? They just roll off the tongue. So yeah, anthropocentrism and ecocentrism are usually seen as opposites. And the centrism part means that the you are centered around something that you find to be the most important, right? And the anthropo refers to human beings and eco to nature, right? So anthropocentrism is thinking in a way that foregrounds humans, right? And that takes the interests of humans into account foremost. So the rights to nature, for instance, are anthropocentric, right? Ecocentric is the valuation of nature for its own sake. So one of the more sort of diffuse claims in the rights of nature community is that the rights of nature are ecocentric because they're supposed to be respected, enforced, also granted, irrespective of human interests. So there's the basic distinction between anthropocentrism and ecocentrism.
Okay.
Whether that works, whether you can really keep them separate, whether it even matters if you keep them separate, is something that I discuss in the book. And I personally fall on the side of, it doesn't really matter that much in particular situations. And also I think personally it's not particularly helpful to set them as a dichotomy. Right?
Okay, good.
So that's
But you dropped already the N word.
Which one is that?
Nature. Oh yeah, that can be very confusing. Nature.
Right.
There are various ways in which we think of nature, and I thought it might be helpful here to kind of to structure that a little bit, right? Especially in Western thinking versus now the sort of meeting of different traditions of thinking. When we're talking about rights of nature, there's a lot of claims that it's from also deeply invested in indigenous philosophies and worldviews. So I thought it might be interesting to kind of talk about what nature. What we mean by that, how we see it, and would you?
Yeah,
because you
sure.
do so in your book so well. So I'm just.
Yeah. You're really asking me for very easy definitions here. Let's lay the basis with the most difficult, like the most contentious.
I know
things.
how to pick them.
Yeah, you do. Okay, so nature, capital N nature, which is often what we mean when we say rights of nature. In my view, is an entirely Western construct. And this is not just me saying it, there's a whole line of literature, particularly a lot of critical anthropology, the work of Philippe Descola, of Eduardo Viveiros de Castro, which if you don't know, I really urge you to read, it's amazing, that show that this idea of nature is always opposed to culture, right? So nature for the Western imagination is the background on which cultural, social, civilizational processes happen, right? And it's also, because of that, is what you're trying to escape in some way, right? And if you think of modernity and modern development in particular, right, it's really a process of escaping the forces of nature and becoming as independent from them as you can, right? So like, even in this setting where we find ourselves, I'm looking out the window, in the center of Brussels, all of this sort of is also meant to tame, right, processes that are beyond your control. It's supposed to control them, right? So there's a stark opposition there in nature, culture, and we may not mean that when we use the concept. We may think ecocentrically, right? But there's a history that comes with it, regardless of our intention in a way.
But in everyday parlance, like you notice, right, this notion of like, I like going into nature.
Sure.
I don't know, like I need more nature in my life. So as something that is outside of us right now, something that is that is out there to be sought for, but that somehow in the urban context or the modern context, we have somehow separated ourselves from.
Yeah, but that's really connected. I mean, the two really go together, and this comes from the reaction to rapid industrialization, for instance, was Romanticism, right? Which is the opposite. It says nature is sublime, nature is where you go to find yourself, but that does nothing to change the opposition. You see, you're still talking about the nature out there.
But are there any alternative ways of conceiving of nature? And one of the things I found very interesting in your book is you talk about this contrast, or perhaps not dichotomy, but this difference in totality, nature as a totality, and versus perhaps like natural relationships with natural formations that are very specific and local.
Yeah.
Could you talk a little bit about that, and
Absolutely.
where do we see that happening, and why is that relevant, perhaps also?
Absolutely. So indeed, like that's why I said, capital N nature, that is supposed to describe everything, right? Whereas there's other ways of conceiving of it, and other ways in which people do not only conceive but practice, right, their relationship to the environing world, which are really concerned with places, and with places that are very specific and have their own life. They have their own character. You get to know them intimately. They may be considered to be part of your genealogy, right? To be part of who you are. Whereas to say nature is part of who I am is to say something quite banal, right? Is to say, I am a mammal. Of course. But there's other ways that, don't necessarily have this type of position because they are fundamentally relational, right? They understand the surrounding world to not be a background, but a condition of their own existence in a deep way. Right? So I think that's a different way of thinking about it, and also of practicing relationships in the world.
I came across something that I'd never ever read before in your book, and maybe this is just for me. I need you to explain this. Ecotheology. Honestly, I've never seen this word before, and I thought maybe you could explain what do you mean by that. Is that something you coined yourself, or?
I don't really know.
Okay.
I don't think so, but in relationship to the rights of nature, I think so. But again, the idea is more important, right?
Yeah.
So the ecotheology is really connected to this idea of totality, right? And to seeing capital N nature as something that structures reality in the same way that theology does, right? Which is a very hierarchical way, right? And in ecotheology, the idea is that humans have a privileged and special relationship, maybe even responsibility for nature, because we have the kind of consciousness we have. So in a way, nature comes to know itself through human consciousness, which really elevates, us above all other creatures. And in very formal ways, this idea of nature as totality resembles a divine ordering of the universe. So that's what I mean by ecotheology. And I think, again, whether one intends that or not, I think, the concept of nature as totality really kind of brings that with it. And even if you're sort of secular person, you inadvertently think about nature as a great chain when you think about it as totality. And I think there's other ways, you can think about it as a network, as a web, as not actually being ordered in any particular way.
Would that still fall under ecotheology, or
no,
that would then
no,
be a
that
departure
would,
from it?
exactly. That's sort of to make the contrast. Yeah.
I really liked it, and I think it's really interesting, and maybe for the interested reader, I think it's really interesting how in your book you trace sort of a genealogy of some sorts of this development of ecotheology in Western thinking. And you look at America, a little bit of Europe as well, right?
Yeah, South America.
Yeah, South America as well. And I think that's really interesting. But again, that's for you to read and us to know already. But I want to get into the rights of nature movement, right? And I thought your book was the first place I saw like kind of an overview, historical overview of what was the first time rights were granted or acknowledged of nature to what we're seeing now. At least like for me, like the last thing I had heard about was New Zealand, and that was quite like, whoa, New Zealand is giving rights to nature. And I thought it would be nice for you to like recap that a little bit quickly, like where does it all start and where are we now a little bit?
Absolutely. So, I'm far from original in recounting this history. I build on a lot of other scholars that have done so. But basically, there's two histories that meet, right? The way I see it, at least. There's an intellectual history, which starts in the 1970s. It has earlier roots. You know, part of what I show in my book is that there's no beginning.
There's no beginning, yeah.
Right? You're always really just recirculating in new ways and posing problems anew, right? So really, there's the intellectual history. You know, it's convenient to say it starts in the 70s, but really, you could go back to natural right in antiquity and so on and so forth. Fine, but for the purposes of illustration, it starts in the 70s in the work of certain legal scholars and legal thinkers that advance this idea that it's possible to think about rights in relationship to nature and not just humans, for instance.
Is at the same time, because I'm very much into animal rights, would you also position this sort of this legal doctrine starting to develop also for animal rights, extending rights to animals in a non-human centric way also around that time, or was this specifically separate about rights of nature?
Right. No, the animal rights is much earlier and has a sort of longer history. And in a way, strangely, they develop quite in parallel after a while. Like, they don't necessarily talk to each other very much. And even today, I feel like that's the case. But it's a different topic altogether. So you know, part of the history is sort of intellectual in terms of proposing these ideas, and then it really comes into its own in 2006, where you have the first municipal ordinance that grants rights to nature, and that's in Pennsylvania, in a borough of Pennsylvania, Tamaqua Borough. And there, the area of the municipality receives rights, and that's done really to oppose certain industrial practices, particularly the dumping of toxic sludge, right? And that is not particularly successful because of the level of the law. You know, it's municipal, so it doesn't really trump anything. But it has the immense credit of introducing this in practice. And 2 years later, in 2008, you have the Ecuadorian constitution, which was being rewritten in that period, that has rights of nature at a constitutional level.
2 years later?
Yeah, in 2008, yes.
Very different places. How?
Very different places. Well, some of the same people were involved, and this idea really started to travel. And then after Ecuador did this, you know, it was very well covered internationally because it was striking. You know, you write the constitution, and in it you give articles, you know, nature has rights. And that really opened the door for other people to experiment in other places. And then Bolivia followed in 2010. And then what you mentioned, New Zealand and India and Colombia and Bangladesh. And now we're in a moment where I can barely keep track, you know. And there's, in fact, I know, you know, several people and projects that are working on trying to understand what all the cases are, you know.
And is it mostly judicial cases, or is there just as many legal, I guess, also constitutional reforms in that way?
There's a bit of everything. There's a bit of everything, really. And in fact, part of the difficulty, because it's early, you know, is to even know what to count. So now we're really in a flurry of activity, and I think because it responds to a real need to change fundamentally, you know, how we relate to the environment world. And you know, now we have this legal mechanism that we can test and see what does it do. But what I show in the book is that it's worthwhile paying attention to the differences, and that there's a risk in saying all of these cases are rights of nature in a particular way. You see. So, for instance, you know, the differences between New Zealand and Ecuador are in a way more important for radical thinking going forward than to assimilate them.
But before we get into that, because I was hoping we'd get into that, I'm just a little bit curious as to like maybe is some of it happening in Europe as well? These sort of innovations, these cases, are they also happening in Europe, or is this mostly happening in places far, far away from us right now?
Well, it definitely didn't start in Europe on a practical level, but it's getting closer and closer. So to my knowledge, there's nothing yet set in stone. There's no cases you can point to and this has happened, but there's a lot of initiatives that are trying to make this happen in Europe, yes.
Oh, at the EU level as well, you think?
There's people working on that.
Right.
There's also people working on a universal declaration of the rights of nature.
Oh.
So at the global level. As I said, there is...
At the UN or?
Yes.
Okay.
Yeah, there's a bit of everything.
Okay.
Yeah.
Exciting times ahead.
Yeah, absolutely. It's really, it's very exciting.
Listen, so I think one of the things like you said, it's important to, you suggest just now, you talk about how it's really important that we study these differences because the devil's in the details. And there's one particular legal standing framework or nature of rights. What happened in New Zealand, would you characterize this as a legal standing reform or a nature of rights, or does that matter at all?
I don't think it really matters. I think it's more about, I think it's worth getting a little bit into the characteristics of what happened there.
Yeah.
Because it's very particular to New Zealand. You know? And I think, again, that is a difference between nature and place-based. So I think that illustrates a little bit what rights of nature can look like in practice when you're really concerned with a place and not with nature as such. So there's two cases in New Zealand, one from 2014, one 2017. In 2014, a former national park called Te Urewera, that is the ancestral home of Tūhoe, which is a Maori descent group, received legal subject status, legal personality status, right? But the way this was achieved is because in New Zealand, the different Maori descent groups have had a very conflictual relationship with the Crown, with the New Zealand government, to say the least, because it's a settler society. And I won't get into the nitty-gritty, but because of a particular political and legal processes, in the 1970s and in the 80s, you had this tribunal set up that could hear claims against the government that went back all the way to 1840, when New Zealand was basically founded through the Treaty of Waitangi, which was signed between the Crown and a lot of Maori chiefs, though not all. And Tūhoe never signed, right? And the most conflictual relationship of all was between Tūhoe and the Crown. They had all-out wars. There was a lot of atrocities committed, and the lands of Tūhoe became, a national park, which is kind of adding insult to injury. Now it's a kind of reserve for settlers to enjoy. So basically,
as in a national park where the Tūhoe could no longer live, or
no,
they
could
in a
live.
Reservation sort of.
Neither really.
Okay.
But the rules of the Department of Conservation was the one that managed.
Okay.
That basically was the governor of this national park. And what happened is that as a result of this claims settlement process, Tūhoe became, or rather, Te Urewera received ownership of itself. So it went out of the privileged relationship it had with the Department of Conservation, and it became a legal person. So it's its own legal entity. And in order to represent it as such, Tūhoe form a board that can speak on its behalf, right? And that really allows for Tūhoe to introduce their own legal traditions that are evolving, and hybridizing all the time, to be able to take their relationship with their own ancestral home further.
Yeah.
And I think that's a really interesting thing that happened there.
So there is. We have to start wrapping up. But I really love the work you've done and analyzing and deconstructing and really studying the New Zealand, the two cases. But I just wanted to touch upon the fact that now you're describing these indigenous communities having been, and nations been deeply involved in the creation of this this reform, I guess, or this development.
This event,
This event, yeah. As part of their decolonial, I assume, like that's how I saw it, like as a decolonial struggle. But you know, in your book, you also talk about the ways in which a lot of these ideas of indigeneity and indigenous philosophies are somehow meshed into these eco-theologies and these, and some of them in terms of like constitutions and so on. But you see, you see a very strong difference. And I was hoping you could touch upon what makes these so different. What happened in Ecuador, for example, in Bolivia, and what happened in New Zealand. Where do you see that we need to be mindful that this is a very different development?
Right. Well, first of all, I mean, I think it deserves saying at the outset that in a lot of rights of nature cases, indigenous activism has been really important. Part of what I question in the book is that philosophically, the level of concept, the big N nature is something that accurately grafts onto indigenous legal traditions. And that's why I think that in New Zealand, though it's not perfect at all, and we can discuss about how the colonial enterprise still works through that agreement in some ways, but there was a lot of space for tuhoi tikanga, which means law or custom, right? Whereas in other places, the indigenous communities had a lot to do with it, in mostly strategic terms, as this being something else that they could use in the decolonial struggles. But I think it's a far cry to say that you know, the rights of nature come out of indigenous philosophies, because I think that blunts the possibility of actually having completely different ways that we learn from indigenous legal traditions of fundamentally reforming our relationship with the natural world.
Yeah. I was struck by, I have also always kind of been taught that indigenous philosophies are like, or indigenous legal practices or cultural, you know, traditional practices are all, you know, like the indigenous people are the guardians of nature and so on. I thought it was really interesting how you showed that in New Zealand, these communities specifically rejected this notion that they would be guardians, but yet pointed and made sure that in the law there was room for the spiritual or sort of ancestor guidance and entities that they considered to be the guardians that they were supposed to learn from, for it to find a place in the law and into this board, or and how that's going to operate in the future. Already started operating, and that was already for me like a great, like a moment, aha moment of like there's so much that we think is indigenous but really isn't at all, and so thank you for having found the time to come here and talk to us a little bit, and
Thank you very
also
much.
having found the time to write this book. I think that there's so many really important lessons that you offer here, and I guess also warnings for the future and where we're heading towards for us to stay critical, and not just mesh it all together into one big movement.
Yeah. Well, I think, you know, if we can end on this, I think whenever orthodoxy sets in, it's time to think again.
Yeah. Great line. Whenever orthodoxy sets in, it's time to think again.
Yep.
Thank you. That's a great ending.